Madam Deputy Registrar, would you please call the matter?
Thank you, President. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize, delivery of reserved judgment in BZCV number 3 of 2024 between Controller of Supplies, Minister of Economic Development, Petroleum Investment and Trade, the Attorney General of Belize, and Gas Tomza Limited, Western Gas Company Limited, Southern Choice Butane doing business as Zeta Gas, and Belize Western Gas Energy Limited. The members of this afternoon's panel are Mr. Justice Anderson, presiding judge.
Good afternoon, Counsel.
Madam Justice Raj North Lee.
Good afternoon to everyone.
Mr. Justice Barrow.
Good afternoon to all.
Mr. Justice Jamadar.
Good afternoon to everybody.
And Madam Justice Unonewu.
Good afternoon, everyone.
May we have the appearances, please? Thank you.
My lords and my ladies, I appear, Edward Fitzgerald, for the first and second appellants with my learned friend, Mr. Andrew Marshalak, of Senior Counsel, and we apologise that Angeline Welsh is unable to attend today, but sends her apologies to the court.
Thank you, Counsel.
Good afternoon, Your Honors. Ileana Swift on behalf of the third appellant, and I'm led by Senior Counsel Mr. Eamon Courtney. He apologized for his absence today.
Thank you.
If it pleases Your Honors, I'm Douglas Mendez, appearing with Godfrey Smith, leading Luke Hammersmith and Hector Guerra on behalf of the respondents, the respondent companies on the appeal, and the cross appellants.
Thank you, Counsel. So the court has come to a decision in this matter, and shortly I shall read a summary of that decision. Two small points before I begin. First, the court acknowledges its gratitude to counsel for their assistance in helping us to reach our decision in this case. We found your written and oral submissions admirable and instructive. Second, I issue the usual reminder that the summary is not to be regarded as an authoritative text of the court's judgment or to be cited as authority for its reasoning. The only authoritative text of the judgment will shortly be published on the court's website. The appellants to the appeal and respondents to the cross appeal are the Controller of Supplies, the Minister of Economic Development, Petroleum Investment, Trade and Commerce, and the Attorney General of Belize, hereinafter collectively referred to as the government. The respondents to the appeal and appellants to the cross appeal are Gas Tomza Limited, Western Gas Company Limited, Southern Choice Butane Limited, and Belize Western Energy Limited, hereinafter collectively referred to as the gas companies. Liquified petroleum gas, LPG, is widely used for a variety of purposes in Belize. It was sourced from the United States Gulf Coast to suppliers across Central America, and then imported by land into Belize by each of the gas companies for distribution. Together, the gas companies control the importation of LPG into Belize for over 20 years. The government embarked on the National Liquified Petroleum Gas Project, NLPG project, with the goals of ensuring the stability, quality, and affordability of the LPG supply, the creation of climate resilient infrastructure for LPG, the minimization of smuggling of LPG, and the protection of the health and safety of the people of Belize. The National Gas Company, NGC, was created to drive the NLPG project. There was a definitive agreement between the government and NGC, which contemplated the importation of LPG wholly by sea and the construction of supporting infrastructure for importation, distribution, and supply of LPG throughout Belize. Subsequently, the National Liquified Petroleum Gas Project Act, the original act, was enacted to give effect to the definitive agreement. The original act introduced a regime whereby LPG would be exclusively imported by NGC, customs and excise duties, stamp duties, environmental taxes, and others. Following the passage of the legislation, the gas companies instituted a claim challenging its constitutionality. They argued that the monopoly conferred on the NGC, together with the various tax exemptions, caused them the loss of a substantial proportion of their customer base. They contended that the original act violated their rights to the enjoyment of property, to work, to freedom of association, and to protection under the law and equality of treatment guaranteed by the Constitution. At the close of the trial, but before judgment was rendered, the original act was amended by the National Liquified Petroleum Gas Project Amendment Act 2021, the amended act, making the importation of LPG by other companies possible. The amended act provided that to obtain a license to import, companies would now be required to receive, store, and subject to testing their imported LPG at the NGC's terminal or an authorized import landing terminal with a minimum storage capacity of 1.5 million US gallons. The gas companies claimed that the amended act continued the unconstitutionality of the original act, but they amended the particulars of their complaint. They complained that the amendment preserved the NGC's monopoly due to the unreasonable and or unattainable requirements for importation of LPG, and sought compensation for breach of their rights and vindicatory damages. The parties agreed on the issues to be tried by the court. As regards the loss of property, the claim was that through the amended act, the government had compulsorily acquired the goodwill of the gas companies without compensation and had imposed onerous and unreasonable conditions to engage in the business of importation of LPG. The trial judge found that the amended act compulsorily acquired the gas company's goodwill without compensation, but the other claims were dismissed. Specifically, it was held that the conditions imposed by the amended act were a matter of executive policy and did not breach the gas company's constitutional rights. The trial judge also found that the amended act removed the exclusivity clause allowing other companies to apply for an import license and to import gas through an authorized facility they built or through the NGC terminal. Therefore, it was not inconsistent with the right to work or freedom of association under the Constitution. Additionally, the amended act applied uniformly to all potential importers. Therefore, it did not result in unequal or discriminatory treatment. The gas companies were awarded damages of a cumulative sum of Belize dollars 10,896,751.20 for the breach of the protection from deprivation of property under Section 17(1) of the Constitution, but were not granted vindicatory damages. Each party was ordered to bear its own costs. The Court of Appeal upheld the trial judge's finding that the amended act violated the company's right to property by causing a loss of their goodwill, which was acquired by NGC without provision for compensation. The Court of Appeal did not accept that the characterization of legislation as regulatory or part of executive policy automatically meant that there was no taking, as it was possible that regulation could go too far and thus unlawfully interfere with the enjoyment. The court held that there was no rational connection between the conditions imposed and goals in the public interest as advanced by the government. The Court of Appeal also found that the gas company's right to work was violated as an unjustifiable legislative fetter was placed upon their ability to engage in their business of choice, the importation of LPG, by requiring construction of a 1.5 million US gallons storage facility or passing LPG through the NGC terminal. In finding this constitutional breach, the Court of Appeal ordered the amendment of Schedule 2 to the amended Act to delete the condition that required each authorized import facility to have a minimum storage capacity of 1.5 million US gallons. As it relates to freedom of association, the Court of Appeal found that this right inures to collective groups with a common interest and properly excluded social and business relationships of a private nature, such as that between the gas companies and NGC. As for the right to equality, the Court of Appeal applied an improper motive test and did not find a constitutional breach, since the gas companies could not show that any difference in treatment was unfair because it was motivated by some improper motive or purpose. The gas companies also argued that the original act was void ab initio, and therefore any subsequent amendments were a nullity. However, the Court of Appeal was not persuaded by this. Both parties to the litigation appealed to the CCJ. At the hearing of the appeal, the gas companies abandoned the ground of the cross appeal that the original act was void ab initio and that the amendments made thereto were a nullity. The remaining issues for the CCJ's determination concern the degree of judicial deference owed to the legislature in relation to legislation of a social economic nature, as well as whether the amended act contravened the gas company's rights to property, work, freedom of association, and equality before the law. Depending upon its determination of these issues, the CCJ will determine whether the matter should be remitted to the High Court for assessment of damages and whether there should be an award of vindicatory damages. Anderson P. delivered the lead judgment for the majority and first considered the principles of judicial deference and the presumption of constitutionality. He affirmed that while the legislature should be afforded a generous margin of appreciation to shape socio-economic policy, courts must remain the ultimate guardians of constitutional rights. The presumption of constitution that there could be an explicit or direct taking of property or a regulatory or indirect taking of property under Section 17 of the Belize Constitution. He found that there had been no explicit or direct taking of goodwill and went on to consider whether the amended act was regulatory and had the effect of an indirect taking by being a substantial and disproportionate interference with the goodwill of the gas companies. On the facts of the case, he held that the gas companies failed to adequately plead or which had not been forthcoming. On the right to work, the majority found that the constitutional right to work guarantees the opportunity to engage in a trade or business, and that this right may be extended to corporations. However, it was held that there was no breach of this right, as the gas companies retained the ability to, and in fact, continued to operate their LPG businesses. They had not been deprived of the opportunity to work, even if the conditions for importation, commercial in nature, which were safeguarded by other constitutional protections. The requirement to use the NGC terminal did not amount to force, did not amount to force association in a constitutionally impermissible sense. Further, the majority found no breach of the right to equality before the law. The court reasoned that the NGC and the gas companies were not similarly situated, as is required to find a breach of this right, given the NGC's investment and role in the public-private partnership. In addition, the majority found that the differentiation in treatment was based on legitimate recognizing the public importance of the issues raised and the reasonableness of the gas companies in pursuing the litigation. In a concurring opinion, Barrow J. focused on the issue of the loss of goodwill. He found that the fact that the gas companies continued to operate their businesses contradicted their claim that the goodwill of their businesses was acquired or taken. It was also observed that the gas companies had no distinguishable importation business to which goodwill could attach. As it relates to the right to work, this issue was dwarfed by the preceding finding that the legislation did not seize the consumers or customers of the gas companies. The opinion posited that the finding of a breach by the Court of Appeal reflected its failure to appreciate that the gas companies were actually in the business of reselling and not importing. This involved the process of the LPG being trucked overland into Belize by the foreign suppliers of the gas companies, making importing and transporting ancillary to the distribution business of the companies. Additionally, the gas companies had the option of purchasing LPG from the NGC for distribution, even if it was less profitable for them to do so. As it relates to freedom of association and protection from unequal treatment, the judge agreed with the Court of Appeal in finding that there were no breaches of these rights. The gas companies had not begun to explore the option of building a terminal or importing through NGC's terminal or negotiating what concessions and treatment could have been available to them. In another concurring opinion, Honorable J. focused on the claim by the gas companies that their right to equality under Section 6.1 of the Constitution was breached. She found that the gas companies did not prove a prima facie infringement of this right. They did not substantiate their contention that the amended act prescribed conditions for importation that were unattainable by entities other than NGC, and thereby perpetuated the monopoly on importation that the original act had conferred on the NGC. The judge emphasized that the amended act did not prescribe that construction of an import facility with a minimum storage capacity of 1.5 million US gallons is a prerequisite for importation of LPG into Belize. Rather, receipt, storage of imported LPG at an authorized import facility that meets the minimum requirements so that the product can undergo the requisite testing by or on behalf of the government is a condition for importation of LPG into the country. Even if it was not feasible for the respondents to construct such an import facility, they could still obtain an import license once they complied with the tendering procedures and passed the imported gas through the NGC's terminal or an authorized import facility built by another entity which meets the minimum requirements. The gas companies did not satisfactorily explain why importing LPG through the NGC's terminal was not feasible. Honorable J rejected the improper motivation test adopted by the Court of Appeal for establishing a breach of Section 6.1, which required a claimant to prove that any difference in treatment was motivated by an improper reason. Reading Section 6.1 together with Section 3 of the Constitution, she found that where a claimant had made a prima facie case that a law infringes the right to equality, the other party would bear the burden of demonstrating that the law can be justified in the public interest. She reasoned that in assessing whether the law could be so justified, it was appropriate for a court to give consideration not only to whether the difference in treatment is rationally connected to a legitimate objective, but also the proportionality of the measure. Jamadar J. dissented. He found that the constitutional rights of the gas companies were breached relating to their right to property and their right to work. The judge examined the notion of the presumption of constitutionality and compared its usefulness as a burden of proof and a canon of construction in interpreting constitutional provisions. In socio-economic policy-making legislation or executive actions, the court is, through the separation of powers, the final arbiter of whether constitutional standards have been met. Further, he emphasized that in proving that a constitutional infringement has occurred, there's a two-stage test to be applied. One, a claimant must prove that prima facie their right has been infringed, is being or is likely to be infringed, and once this has been established, two, the burden shifts to the state to establish that the limitation on the right is, among other things, justified. The more substantial the interference, the greater the obligation on the state to provide a cogent justification and fulsome disclosure. In examining whether the gas company's rights were contravened under Section 17 of the Constitution, the judge considered that both lower courts concluded that the goodwill of the gas companies was lost because of the monopoly created by the original act and continued by the provisions of the amended act. The result of the original act was an immediate loss of business, customer base, and goodwill. This amounted to a deprivation and or taking of property due to the adverse effects of its interference. Jamadar J. opined that the state did not discharge the onus on it to satisfy the scrutiny of the justification test. In his opinion, there was no rational connection in requiring the gas companies to build multiple 1.5 million US gallons storage facilities, and no proven justification, especially with no guarantee that they will be granted an import license. Further, he noted that the level the playing field justification for the amended act failed because of a difference in the requirements that the gas companies were subjected to compared to the NGC. The conditions placed on the gas companies also impacted their ability to engage in work of their choosing, since they could no longer import LPG. Also, in his view, it was unrealistic to determine that the importation of LPG was not a significant aspect of their enterprise that was adversely affected. By agreeing with the Court of Appeal that there had been contraventions of sections 15 and 17 of the Constitution, the judge would have remitted the matter to the High Court for an assessment of damages. He reserved his position on the other issues in dispute. In the result, having regard to the opinions expressed, the appeal was allowed and the cross appeal dismissed. The court made no order as to costs. That then, counsel, with the interruptions you have experienced, is a summary of the judgment of the court. Can the court be of any further assistance to you in this matter? Appellants? Is there anything further from the appellants?
Your Honor, I don't believe so. I see Mr. Fitzgerald is trying to say something, but it's not coming through. Nothing
Muted.
further, Your Honor.
Thank you. He's muted, and therefore maybe that's why he's not coming through.
Yes. But I don't think it's responding to whatever he's doing there.
Yes. Well,
There's nothing further, Your Honor.
thank you very much,
Thank you.
Mr. Marshallek. Is there anything from the respondents?
Nothing from the respondents, Mr. President. Thank you very much.
Thank you, Mr. Mendez. Third appellant.
Nothing from us, Your Honor. Thank you very much.
Thank you very much. And again, thank you for your assistance in this matter. It was greatly appreciated. Thank you very much. Madam Deputy Registrar, will you please close the proceedings?
Thank you, President Anderson. Thank you, Madam Justice Rajnath Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Unwaniru. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.
Thank you very much.